The talk that I'll present today comes from, portions of it certainly come from Affective Justice, my book that came out with Duke Press in 2019, early 2020. And in many ways, it's an attempt to think about these transnational processes that have typically been seen as a manifestation of contemporary globalization in the present. And so the one that I'll focus on, of course, has to do with the International Criminal Court and the rise of international justice. So since it came into force in the Rome Statute, or through the Rome Statute in July 2002, the International Criminal Court, a court with jurisdiction among 121 member states to adjudicate 4 core crimes, genocide, war crimes, crimes against humanity, and the crime of aggression, has perhaps done more than any other institution to generate the contemporary rule of law movement and subsequent critiques of this movement in responses to localized controversies. Now, under the Rome Statute for the International Criminal Court, state actors under the jurisdiction of the court are held responsible for protecting the lives of their citizens from mass atrocity violence, genocide, therefore committing to ending impunity of those who have evaded justice for too long. By attributing high-ranking leaders, by attributing to high-ranking leaders the actions of foot soldiers that are ordered to kill, the ICC has introduced various modes of criminal responsibility, from superior responsibility, command responsibility, joint criminal enterprise, ordering, and so forth. Now, the ICC's jurisdiction then is celebrated. It's celebrated as being complementary to national courts, and it means that following Article 17, if a state is unable or unwilling to genuinely investigate crimes within its jurisdiction, the Office of the Prosecutor can claim the jurisdiction to do so. Now, through these legal technicalities, agents of the court are expected to demonstrate that those who committed the relevant atrocities had effective control to anticipate, to stop, or command such violence. And though it operates with the force of law, it also does so without the privileges enjoyed by states. So instead, it depends on member states and member cooperation, as well as widespread civil society mobilization. So court agents under the court's jurisdiction can trigger the jurisdiction for the court. And so ultimately what we're talking about is a mechanism that is not a state mechanism and doesn't enjoy the privileges that a state would: its own police force, its own jail, its own state mechanisms to command and enforce prosecution. Instead, it follows other mechanisms. And this is really at the heart of the problematic for this domain that we understand as international criminal justice. Now, what happened was that the ICC, of course, the major pushbacks and the significant turmoil emerged when the ICC prosecutor issued an arrest warrant for the arrest of President al-Bashir. And this, of course, marked the first time that the United Nations Security Council had invoked its referral power under the Rome Statute, Article 13b, to refer a particular situation to the ICC prosecutor. And the referral was predicated on the UN Security Council's determination that the situation in Sudan constituted a threat to international peace and security under Article 39 of the United Nations Charter. Now, just the backdrop for this is that on April 27, 2007, the ICC had issued arrest warrants against the Janjaweed militia leader, a number of leaders, as well as Sudan's Minister of Humanitarian Affairs, Ahmed Haroun. Then on July 14, 2008, the prosecutor requested an arrest warrant against former Sudanese President Omar al-Bashir, and that was issued in 2009. Now, what happened there was that the government of Sudan objected to the exercise of the court's jurisdiction, arguing that both the UN Security Council and the ICC violated the country's sovereignty, given that Sudan had not ratified the Rome Statute for the ICC. In immediate reaction to the arrest warrant against al-Bashir, Sudanese the Sudanese government expelled more than a dozen humanitarian aid organizations and workers, leaving more than 1 million people without access to food, water, and healthcare services. And setting the conditions, of course, for controversy, which further complicated peace negotiations that were underway. So in addition to that, there were a number of other objections, including the African Union's objection. And part of the jockeying and the negotiation emerged when the UN Security Council showed minimum response to the AU's request, considering it only briefly and declining to act on it. Now, let me just say a few things about the AU before introducing the concept of affective justice and why should we care and how is this relevant. So state agents of the AU, the African Union, initially strong supporters of the ICC, have recently adopted an oppositional stance that is especially telling. So the AU, as many of you may know, is the largest Pan-African organization with a mandate, with an expanding mandate to achieve greater unity, solidarity, political cooperation for African peoples. In regard to President al-Bashir's indictment, the AU insisted that this, and I quote, "The search for justice should be pursued in a way that does not impede or jeopardize efforts aimed at promoting lasting peace," end quote. It also reiterated a concern about the possible misuse of indictments against African leaders. And in the end, the UN Security Council denied the AU's request, resulting in the AU's 2011 decision not to cooperate with the surrender of al-Bashir in The Hague. And of course, a lot of things have developed since then. And of course, the al-Bashir's government has toppled, but he is not in the jurisdiction of the International Criminal Court. And the dispute and the controversies, of course, about the remit of the court, whether or not ICC African leaders should submit to the court, of course, are at the center of emotionally driven justice practices, and at the center of which I refer to as affective justice. And so what is affective justice? Why should we care, and what does it have to do with the talk that I'd like to give today? Well, it's a term that I advance for understanding people's experiences of justice through embodied and always contingent, contested assemblages of affective practices. However, until recently, the study of emotions and affects have taken place primarily in the sphere of psychoanalysis and have been predominantly focused on questions related to the individual and his or her private relationships. Studies of the social, that is what people do and what it means, have consumed a significant part of anthropological thought over a century. The scope of interest has shaped cultural anthropology's focus on cultural practices and meaning making, as well as social change. However, it has been difficult for social scientists to understand the psycho-interior lives of the people we study. Scholars in sociocultural anthropology, for example, have approached questions of the psychological and psychosocial and biosocial domains. But over the past 3 decades, the emotional turn has provided an entrance into assessing the interior and exterior lives of an individual. And this shift has brought to the fore critical questions about precognition, about cognition, about related constructions of emotion and their consequent expressions. However, in law circles, mainstream, and especially including international law circles, mainstream legal academics have not necessarily viewed the study of emotion as an important domain of study, much less the study of affect. Rather, its study has been significantly dismissed by positivists as an interesting luxury, rather than as a key domain for understanding complex issues. For many in that camp, law is objective and thus legitimate, and the study of emotions, of course, are then seen as distracting us from issues related to the rectification of injustice. In fields of international law and human rights, questions concerning the role of emotions have often been dismissed as highly personalized and not appropriate topics of international law and politics. Yet, despite the insistence of those who hold this position, the study of emotions has risen as one of the central questions in Western jurisprudence as it deals with the relationship between law and social values. This is especially the case in relation to how lawyers deploy techniques to elicit particular emotional responses and downplay others. The recognition of this significance has led to the emergence of a growing field of the study of law and emotion. And indeed, the social scientific study of law and emotion is becoming a domain by which scholars have sought to locate the place of emotion as central to public policy, democracy, and decision-making. So in this regard, law and emotion scholarship can be seen as defying legal positivism by challenging claims related to law's value-neutral rational features. In critical theory, what we've seen is a shift to the study of emotions, but also a shift to the study of affect, the biosocial domain. And so this turn to affect was shaped by limitations of post-structuralism as well as deconstruction, and sought to take on discussions about culture, subjectivity, identity, and bodies, because of course embodiment was a core part of the emergence of affect and affect theory. So much of that literature, this turn to critical theory and the incorporation of these questions of affect with the biosocial, with the embodied responses, involved a survey of the influence of affect theory. And we saw this in post-humanism and queer theory and history, sociology, approaches to new materialism, arguing that affect, which often is seen as an umbrella term that describes assemblages of nodes, waves, materials, intensities, has replaced Foucauldian discourse as the leading and current critical commentary. And so over the past 2 decades, questions about cultural practices and their relationship to how people feel about those practices that have become the subject of the anthropology of emotion have certainly taken shape. And the role of emotion in social life has preoccupied anthropological thought and certainly has parallel precursors in earlier scholarship. However, understandings of the complexities of emotion in transnational domains is only beginning to take on significance through its interrogations of affect, not only because of its complex signaling relevance in international affairs, but because of the significance of articulating a new geopolitics through which to study the complexities of emotions and affects in traditional life. And so this talk is about affect as a key side of emotions, as a form of justice practice in the sustenance of international criminal law. Though the ethnographic study of international law is only just emerging, its study in legal, international, diplomatic affairs circles have long been concerns with norms, law breaking, and new forms of cooperation. Now, in her publication of Humanities Law, Rule of Law for the New Global Politics, Ruti Teitel argued that now more than ever, foreign policy decision-making occurs in the shadow of the law. And by suggesting that the juridical paradigm shift is primarily discursive, she insists that the expansion of the international human rights system both enables and constrains politics and requires new interpretive principles through which to make sense of the present state of global politics. Now here, Teitel argues that humanitarian discourses have produced the basis on which a larger set of interpretive principles are shaping global politics through a notion of humanities law that are shaped by the law's reach, jurisdiction, personality, and institutionalization. And it's a much longer article in which she makes this claim to think about the nature of the contemporary moment. But what she doesn't consider is the reality that an expanded international legal regime does not necessarily mean that those new interpretive principles form the practices that are currently transforming what justice is becoming in our world. For while what is seen as new international legalism is transforming state-centered lawmaking, My discussion today is that it is not the law in and of itself that produces the tools to implement law's reach through jurisdiction or through institutionalization. Rather, through an affective justice lens, we see that law's humanity is actually propelled by international law's affective practices that both are mobilized by law's technocratic legibility, but draws its power through particular moral economies that shape international law's buy-in or international law's rejection. And so what I'm arguing here is that international lawmaking gains its power to claim power, not through technical legal doctrine and procedures in the way that Titel might suggest and many positivist and other international legal scholars might insist, but rather it's the power to claim power that actually that's actually propelled through the classification and negotiation of technocratic knowledge, which which I will be showing, is driven by embodied affects, as well as technocratic knowledge, but also the regimentation of emotional regimes. And it's those three components, technocratic knowledge, embodied affects, and the regimentation of emotional regimes that I call affective justice, and that I identify as the key components of affective justice. I'm going to just share my screen. I find that it's easier to see the. Okay, so oh, okay. Anyway, it's you also see the other slides, but this is the main slide, the larger affective justice slide. Now, and in many ways, my talk today is organized around these core concepts in which I'm saying that it isn't simply about these technocratic practices that produce law's power or justice's power, but in fact, the rhizomatic interconnection of technocratic practices that actually are deployed through other things. And so affective justice then is the term that I advance in understanding justice through always contingent and contested assemblages of practices that attempt to rectify human suffering through a range of mediated formats. And these practices of rectification of violence, of injustice, involve often embodied responses that are decoupled from lived spaces and histories and relocated to other domains. And central to affective justice then are the ways that emotion and affects are mobilized. They're dislodged from place and reterritorialized to other places. And so the core argument, and in a moment I'll talk through each one of the component parts that I'm arguing are actually at the center of international law's justice. The key argument is that contemporary international justice mobilizations do not exist and flourish through formalized processes, of course, in and of themselves. They gain their power through morally and socially, politically propelled justice practices that are amplified within affective domains. And in this regard, there are two central tropes in these international criminal court domains that are key to the affective, to the way people feel, the way that justice mobilizes the body and engages and invigorates them. One of them is the imagery and the concept of a victim to be saved. And the other is the perpetrator to be stopped. And so this image here is, and especially in the context of Africa, the ICC and Africa is relevant since all of the cases are African cases. And so the figure of the victim, the brown and black, often woman, child, the perpetrator, the brown or black man to be stopped, are the key tropes. And these tropes gain their strength through honed responses to protests that question those formulations and are manifest through what we often see as the dislocation of suffering or the relocation of it in the contemporary commons. And what I'm referring to as the contemporary commons is often the international community. So we have the victim, the perpetrator, and then a contemporary commons, which is we, the people, the international community, that gets constituted often as the third domain of international law's power. And so as such, the victim, the figure of the victim, emerges as a proxy through which law's architecture is retooled, constantly resharpened and made anew as needed. And what I'll do with using a couple of examples is show how this happens through various feeling expressions and narrative devices that are used to expand, displace, and recover strategies to end injustice, thereby innovating new formations as they build on old ones. Okay. So conscious that we've lost some time, I'm just going to try to speed up to move to the case study then. So the component parts, let me just say something about that and then go to the case study. So the first being technocratic practices. These are often in the realm of international criminal law, of course. It's a core component. It isn't the only component, and this is part of the argument that that the domain of legal technocratic practices are key to the management and training and implementation of legality, of course. It's part and an extension of the biopolitical management of life and death that we see in the creation of an international institution like the ICC. And so if we think about the biopolitical management of life and death as being managed through an international criminal body, then we might think about it taking on the role, claiming the role of the conduit of biopolitics. So biopolitics, if we think about biopolitics as understood as having power over bodies, ranging from various techniques of subjugation to control of people and constituencies, then following Foucault, economic, political, psychological, and classificatory domains are actually key ways that the body and populations have been and continue to be used to discipline subjects. And so legal technocratic classification, so what gets to count as a crime, what the subject matter jurisdiction is, what the temporal jurisdiction is of a given case, is all about the legal technocratic management of a case of violence of bodies. That yes, there are technical aspects to the making of, but part and parcel how this becomes a political project, and a project that isn't simply about an objective law, but instead about these affective circuits, has everything to do with the nature of history, the nature of plunder. It has to do with a range of things that shape the biopolitics of feeling, whether or not something is worth pursuing, whether the UN Security Council should intervene in something like Syria, for example. What shapes the impetus for us, we the people, to act, to insist, to mobilize the law. And so central to the technocratic process then is the calling of and the use of tools, legal tools being one of them, to displace other practices, those practices often seen as violent practices. And what we see, especially in the contemporary period, is the emergence of this an encapsulation of the law, what I call legal encapsulation, which is a way of thinking about the narrowing of justice through legal and technocratic means. And this is the critique and the problem that that I argue we see with scholars like Ruti Teitel and others who insist on this contemporary period as a period that's managed through the law in a particular way. So yes, there's a role, they're technocratic domains, but these are shaped by, or how we think about technocratic practice is fundamentally shaped by institutions of governance, courts, but it's also sensorial spheres that, what we think ought to happen through the law. whether or not we should be mobilizing the law for certain purposes. What are the politics that are part of this negotiation? And so that's the technocratic. Then there are the embodied affects, so that often drive this sensorial world that gets inhabited. We see in scholarship on affect that affect is could be seen as pre-subjective, an interface of the body and the sensorial world. It is the visceral, it is the ways that memory lodges in the body. It's the reactions that we feel or have perhaps when we, over a 20-year or a 15-year period, indictment after indictment, all of the indictments are Africans. When you line people up, 20, 30 of the perpetrators are all Black Africans. What is the response? What are the politics of race and racial, what are the racial geographies that are at play? What are the responses that we feel around those powerful sentiments, the sentiments of anger, pain, confusion, hope, and in part, an extension of the embodied affects then in this notion of affective justice is reattribution, and this is the pushback. It's the reassignment of culpability that emerges from bodily responses. Now, the third, because part of the challenge, of course, is how we materialize that. How does one study these inner processes when, in fact, sometimes even those who are having the response are not able to articulate those inner processes? And this is where emotional regimes come in, not as a separate domain or a separate component part, but actually part of the conceptualization of affective justice, that these embodied responses are also regimented socially. They become materialized in particular ways. And this third component involves emotional regimes. And this is where these justice tropes circulate. We might see an emotional regime following William Reddy's work as a set of normative emotions and the official ritual practices and emotions that express and inculcate them, that are necessary underpinnings of any stable political regime. And so I extend this concept of emotional regimes to think about the emotional climates that get changed in rule of law language and anti-impunity language. And we see this in technologically driven campaigns, especially justice campaigns, related to saving victims and making perpetrators accountable. Appeals to sympathy, empathy, mobilizing the power to activate citizens. These are all key components of these emotional regimes that are at play. And so just to advance the argument further, then let me just look at a couple of very quick examples of how this plays out in different domains. Earlier in introducing my talk, one of the tenets, of course, has to do with the African Union's pushback and various African leaders pushing back because all of the cases before the International Criminal Court over its 15 to 20 years of existence, or 15 to 18 years of existence, have been African. The indictments have been of African leaders, African Black and brown people on the African continent. In fact, since 2020, the International Court has issued more than 36 indictments, including 27 arrest warrants and 9 summonses to appear before the court, all of them being African people. So in response to what is often seen as perceived structural injustice, many African leaders responded like let's say I'll point to the Rwandan president, for example, Paul Kagame, and I quote, in a passionate utterance, he responded, and I quote, that the ICC appears to have been put in place only for African countries, only for poorer countries. Every year that passes, I am proved right. Rwanda cannot be part of colonialism, slavery, and imperialism, end quote. And so this comment made in 2009 reflects the perspective of many, certainly the public perspective of many African leaders on the continent who have begun to perceive the ICC not as a mechanism for a more hopeful future, but rather a force that seeks to continue the long and tragic history of exploitation, racism, and the external control of Africans. We see this continuing with discussions by the African Union when in 2011 they refused to endorse the ICC to support the extradition or removal of African leaders, and insisted that it's a form of lawfare where African law is abused to keep Africa in a subordinate position in the global order, end quote. And so this notion of lawfare, the use of law to engage in social, political, or military battles, implies the deployment of law and its institutions to defeat African authorities through displacing perceived sources of violence. And many of these responses, of course, emerged with anger. Various leaders, for those of you that followed this period, there were questions about whether or not the ICC was racist, whether or not the ICC has been put in place to denigrate and to pursue race hunting. And so the language of race certainly was at large in the discussion of the ICC. And what was replaced as a mode of reattribution to push back against the kind of legalities of international justice was an attempt to realign culpability, to instead say, this is not simply about these high-ranking leaders who have committed crimes. This is about long years of colonial inequality and the kind of despotism that we see in Africa as a function of weakened economies, destroyed social systems, etc. And so instead, what we often find through the reattribution strategies is a different strategy in place. The one strategy, we see this in the Kenyan case, this is Jomo Kenyatta, Uhuru Kenyatta, the son of Jomo Kenyatta, who in referencing his father, who was the independence leader for Kenya, in referencing the kind of political plight and the challenges that his father went through, he then attempts to identify freedom fighters instead as the iconic symbolism of justice. So it's not the victim to be pursued or the perpetrator as per the images that I showed earlier, but instead it's the freedom fighter. And we see the way that emotional regimes are used to that end, where Uhuru Kenyatta utters certain words like, we've seen this before. And what he's referring to is the British colonialism of Kenya, the displacement of people over 100 years, and the freedom fighting that led to Kenya's independence, but not before his father, Jomo Kenyatta, was imprisoned by the British officials and then released, and then this led to independence. And so there's a form of reattribution at play in which there's a pushback, and figures like Uhuru Kenyatta will utter particular words in which their constituencies understand the histories that are part of refiguring and reattributing justice and these justice imaginaries. So we see this with emotional regimes, but they're effective because of the emotional affect, because of the affects that are embodied, the feeling of injustice, the feeling of white supremacy that has sublimated people's access to land, the feeling of inequality, the psychosocial responses that get tied in through these narrative strategies that at times people buy and mobilize. And in fact, in this case, in the case of Uhuru Kenyatta, he was actually elected as president of the country after he was indicted by the ICC. So despite his indictment by the ICC, his claimed culpability, the alleged culpability the 2007-2008 violence in Kenya, um, the nature of embodied affects and his ability to mobilize a particular emotional regime with words like "we've seen this before," paralleling the colonial system that imprisoned his father with the International Criminal Court system, which sought to imprison him. And this is a profound, the profound power of what constitutes justice through the articulation of that imaginary is key here. But there's a different imaginary at play, and this is the last example before I wrap up, and that is the anti-impunity imaginary that that has emerged and mobilized support to, and I'll go back to the imagery, to save victims and to make perpetrators responsible. And we see this in the ICC, the idea in Article 17 that where the statute lays out the basis for admissibility of a case before the ICC. The assumption is that a state has the sovereign right to adjudicate alleged violence, but if they're unable and unwilling, then the ICC can pursue certain triggers. But what's important in thinking about the power of the victim to be saved and the perpetrator to be stopped is to understand the kind of practices that are at play, the emotional regimes, the embodied feeling that victims are to be saved. I mean, who would disagree with that, right? That many of us believe that people should not be victimized, that injustice should not happen. And part of the key is to reckon with and make sense of justice making through the practices of justice making, not simply through the legal practices, but in fact, through these embodied and regimented practices that actually produce the basis for legitimacy. And so if we think about the making of the ICC as a modality for justice making, the ICC is not simply a building, this building, or its criminal institution. It's not about a single location or a single set of founders or judges. Its work is far-reaching, multifarious. Its beginning and end go well beyond the statute. Its legal actions precede the making of the Rome Statute, and it follows violence as well as is constituted by it. This global circulation of rule of law actors and actants following Bruno Latour is centrally propelled by moral convictions to save victims and to stop perpetrators. So the ICC's mission operates through moral embodiments in which political commitments against impunity are central to how the component parts of the assemblage function. Yet the morality, emotion, and embodied feelings about injustice are core components of the movement's power. Now, if we think about the movement's power, of course, the declaration to end impunity, no one should be above the law, these declarations that are proxies for ensuring that victims are rescued, that perpetrators don't continue to cause violence against others. And we see this anti-impunity principle communicated time after time, and it takes its form in a number of ways. But there's one in particular that in this final example that I want to share that I think is profoundly powerful in the deployment of international justice, and it's really in large part influential and influenced by Ben Ferencz, who was a former investigator of Nazi war crimes for the Nuremberg tribunals, who himself fled persecution as a Jewish child, and eventually became a lawyer and an attorney at Nuremberg. And one of the poster men for the International Criminal Court. He was there in 1998 at the Rome Conference and continues to be seen as a key person that insists on the duty to prosecute. He's himself a political negotiator. He is 101 years old at the moment, and he really is he comes to draw on the moral authority of international justice. And of course, the referentiality that's at play is the references to Nazi Germany, to Nazi violence against victims, the never again refrain, never again shall this happen. And we see this discourse of Nazi Germany as a central discourse in the kind of narrativization that is part of that moral economy of international justice. So for example, and I'll quote one of Ferencz's responses to the responsibility for crime and the moral economy of this responsibility. And here he recalls the Nazi Germany and the problem of victims dying. And he says, and I quote, I saw the crematorium still going, the bodies starved, lying, dying on the ground. I've seen the horrors of war, more than can be adequately described. The capacity to destroy life on Earth has grown incredibly in the course of my lifetime, which increases the need to set up a mechanism to try to prevent that from happening. There are perpetrators of crimes, there are victims of crimes. They are ready to fight and die for their ideals. They cannot have a fair judgment. You need a third party, a court, in order to determine the facts, end quote. And so here we see in the anti-impunity movement the mobilization of a moral economy, visual imagery, the specter of death, that are at play, that are part of the sentiments of saving, and certainly part of the call that no one should be above the law, and that the law and processes of legal encapsulation end up playing out in their most hegemonic form amongst those in this movement. Okay, so to wrap up then, to conclude, to appreciate the entanglements of effective justice, geopolitics of affects are critical for moving us away from the pre-configured liberal subject that is a maker of international law to reflect on forms of justice making that are actually about much larger conditions of possibility in which some and not others fall under the jurisdiction of international law's orbit. These domains of possibility for producing power that has the power to shape moral value, criminalize some actions and not others, and set the norms through which affects circulate, require that we map the geopolitics of justice differently. So here I'm insisting that it's not legality and technocratic forms of knowledge, but that we think about these geopolitics in different ways. These justice imaginaries, the victim, the perpetrator, in the case of AU mobilizations, and in the Kenyatta example, of course, the figure of the freedom fighter, that's the reattributed fighter. They all operate through emotionally infused icons that draw on deep-seated histories and psychosocial feelings that compel social actions. The notion of a victim becomes an icon of justice, a redemptive body who preserves the traces of past actions and brings them into the present as potentials. As Brian Masumi writes, the body doesn't just absorb pulses or discrete stimulations, it enfolds contexts. Through the vehicle of the iconic body, constructed through the sentimentalized affects, we experience the embeddedness of history in future socio-political effects within our bodies. And this imbrication of the past, whether it's a colonial past, whether it's Nazi Germany, whether it's the imagery of violence, this imbrication of the past and the present through affects becomes institutionalized through what Bill Mazzarella refers to as the pragmatics of institutional practice. Affects articulated through institutional practice, whether from those in the anti-impunity movement or those engaged in Pan-Africanist refusals or reattributions, emerge as emotional appeals used to address larger socio-political concerns. Some emotional forms invoke deeply known histories and reattribute what many seen as illegitimate hegemonies of the past to reframe new justice narratives about contemporary events and actors. What is clear is that multiple traumas over generations elicit a broad range of deep responses. This range points to different ways that people are positioned and call on us to consider the ways that some attribute justice using new terms of engagement. So in the cases and the examples that I've presented today, for those involved in the anti-impunity movement, the rise of this duty to prosecute sentiments emerged and were certainly critical for deepening the discourses that frame the contemporary rule of law movement. But the same was true for later African and post-colonial advocates who joined forces with them in the earlier days to establish the deepening of the moral economy and power of legal accountability for mass atrocity crimes. However, various people, of course, became suspicious. Various African leaders and constituencies became suspicious of the legal power of the ICC. And what we saw was the invocation of European colonialism, discourses of the continuity of colonialism into ICC justice. This was followed by the subsequent refusal and affective dismissal by African states of the ICC. Because of their focus on African leaders. And this has had the effect of subverting this narrative, that is the pro-ICC narrative, by complicating the pursuit of the African perpetrator as the image and instead moving it to the other images like the anti-imperial freedom fighter. And so it's really the response to legal encapsulation. My phone is off. Why is it? So sorry about that. The ringer was off, but it still is connected to the phone. Okay, so to wrap up then, it is the key work about reattribution then. So we have legal encapsulation in which legality comes to constitute justice making through those in the anti-impunity movement. And amongst those Pan-Africanists who are pushing back and using this form of reattribution, we're seeing other figures, emotive figures that emerge, like the independence figure. The key work of reattribution, which is the replacement of legal encapsulation with other iconic figures, is to recognize how legal encapsulation produces these displacements and how those displacements lead to reassignments of meanings. And so key here are the ways that human suffering gets decoupled from particular spaces and reproduced through moral obligations that shape justice in the contemporary period. This decoupling of what justice is and recoupling of justice through reattribution are what produce a new geopolitics of international justice and require that in the study of new global formations, we understand the central role of affects in using power to create power in new justice imaginaries. Consistent patterns of controversies and conflicts within justice narratives force us to re-examine this making of international justice frameworks. Law garners its authority through emotional affects that produce various forms of encapsulation, and these expressive practices reflect utterances that allow relevant components of justice assemblages to exercise their related capacities. And so what's critical here, and I'll end on this note, what's critical is for us to understand what these iconic figures in justice projects do, how they do it, and in what way the desires and fantasies of their narratives emerge, reframing the making and unmaking of international law in relation to the affective theories of transnational practice, allow us to understand how particular affects make justice feelings possible. The emotive figures for invoking suffering are increasingly racially embodied as Black or brown or Muslim or male, and the responses to such racialized justice sensoria have come to look and feel a particular way. But this is not because of something endemic to race or ethnicity or gender or to law itself. Rather, it's because of the racially dominated political economy of extraction, of governance, the symbolics of race that operates within particular assemblages of meaning making, power, and possibility. So in keeping with this formation, the fiction of difference is reproduced according to structures of inequality and particular modes of seeing, feeling, engaging, speaking, by exploring how such figures like the iconic victim or the iconic perpetrator are aligned historically with particular social locations, with particular personal commitments or experiences. We see how effective justice regimes are actually regimented through structuring devices like technocratic knowledge, but also retooled in relation to institutional, historical, and moral orders. These moral orders affirm international justice emotional regimes and make them viable, actionable, or rendered unviable. This, I suggest, is the geopolitics of justice formations in the contemporary period. Thank you. I'll stop there.
Thank you, Kamari, for this thought-provoking lecture you just gave us, which is so special in the context of our Institute for Globalization Studies, where we engage in such interdisciplinary issues around global inequalities in particular. In this case, adding your international legal expertise to the problem made it quite unique. And I expect our audience, with the different perspectives that come will have follow-up questions for you. But first, I'd like to invite you to engage in a discussion with Stony Brook University colleagues, also faculty involved in the Globalization Studies program, and who are experts in some of the fields that your lecture has explored. You've already met Sophia Boutillier, who introduced you earlier. Sophia is a former development worker in Kenya and Ghana who decided to go back to academia and came to the Department of Sociology here at Stony Brook to do her PhD and investigate the field further, the field of international development studies. And Juliette Passer, Esquire, international law practitioner who teaches international human rights and international law in the Department of Political Science at Stony Brook. In her private practice, Juliette is also a sustainability advisor. So Juliette and Sophia, you have specific questions, I know, for Kamari after this talk, so the floor is yours.
Well, if I could start, Kamari, thank you so much for this very profound shift in the analysis of the rule of law. So you have just suggested to us and to the international community a shift from blind justice to effective justice, which I have to ask you a very broad follow-up question. So in these very broad terms, what would be the advantages and disadvantages of pursuing the, the repair of historical and socioeconomic inequities through effective justice? Because if I understood you correctly, this is precisely what you're offering, a different mechanism for analyzing the rule of law internationally. And thank you for that.
Okay, thank you for that question. And it makes sense that you're asking me to further justify it. What do we gain? And in part, what do we gain is that I'm suggesting that we abandon universalism as the basis through which we understand international justice. It's not a useful way to think about the complexity of human difference as well as the nature of inequality. And so what we gain then is a modality that actually allows us to look at specificity. Why is it that all of the cases are African cases? Is it institutionally about white supremacy and racism, or is it about something else? The answer to that isn't easily understood through blind justice, of course, which I think is the undertone of your question. Law is not blind, and the application of the political is far from that. That the context in which all of the cases are African cases has to do with the histories of plunder and inequality in these African contexts. And so it's no surprise that some 50 years later, of course, this state experiment has devastated communities of people in a range of ways, but in particular in ways that for which the US and the global North are not innocent. And so affective justice allows us to think about the different forms of culpability and the feelings of injustice that are actually part of the embodied and regimented nature of international politics. And so that's really the justification, and blind justice won't get us there. Universalism won't get us there. And the presumption of objectivity in the law certainly won't get us there. So thanks for that question.
Thank you. Sophia, your turn.
Sure, thank you, Kamari. Okay, I have a bunch of questions. Some of them are going to be rambling, but I'll start with this one. I'm just thinking about the excerpt you gave from Uhuru Kenyatta about the "we've seen this before," and if you could talk a bit about how affects create the we. You know, who's in the we, and the way that feelings around, you know, who counts as victim or perpetrator, who's being served. You know, the way that affects are informing that group boundary.
Yeah, thanks. I love that question because it actually gave me the biggest aha moment in the research that I had done over the 6 or so years of collecting data, including some of the work at the International Court and at the UN, but also at the African Union. And this question of who is the we is really key to the text and to the talk. It's in many ways the way that we become proxy victims, the we that is the international community, become proxy victims for those who are not at the negotiating table is an interesting move. And understanding the practices that enable that move, I think, are key here. We also see this narrative formulation, of course, in the Kenyatta case, but in so many African cases. There's a profound rhetorical device that played out with the Kenyatta indictment and his election and then re-election, in which it was quite easy to call on and tap on histories of displacement and British colonial degradation in the region, because that was a heartfelt, a very real relationship, the distinction between citizens and subjects, between those that have and those that don't, the colonial and the settler, that these relations are heartfelt, they're deep, they're difficult, and the struggles around the making of the independent nation state that is Kenya are also deeply felt and shared and embodied in a range of ways, regardless of ethnic difference and ethnic variation. And so the ability to establish through discourse, through imagery, through colors, and in a longer presentation, I would have gone in more depth, but what we see are these discursive strategies that establish first the profound alliance and unity that is part of the we that gets constructed as the Kenyan nation, and then the referentiality that happens, which is the linkage to the contemporary moment, and the they becomes the international court, which was the British. So the British and the international court then get discursively linked, and the we goes from the Kenyan people to the Kenyan people who have been violated by an unfair indictment, as is the discourse. And so we see these rhetoric strategies, and these are profoundly critical in the shaping and making of international justice. Whether or not they exist alongside truth value isn't as much the question as the strategies that we've seen play out. And, of course, for those of us deep, so near and dear to US politics, we certainly over the last 4 years and last 3 years of the American elections saw that profoundly playing out in so many ways that, especially and in particular, around not the truth claim, but the domain of knowledge and practice on which people draw. So, you know, the kind of make America great again. All one need to do is utter the word, the combination of words, and through that referentially index George Wallace in 1950s, 1960s, when white was white, as some of my colleagues jokingly say, and when black was black, also jokingly say, as a way to index a moment in which racial demarcations actually meant something in a different way. So, to end on that, the strategies are profound and are critical for understanding how justice is taken in, how it's mobilized, how it moves, how it's practiced. And it's really a key piece of making sense of these processes.
Thank you.
Sophia, do you want to continue with your questions? Because I'm going to swing everybody back into the legal arena and we can do that later.
Yes, Julia, go ahead with one question, and so can Sophia afterwards. And I want to ask Kamari if, considering the little mishaps we had at the beginning with the filters in communication, if it would be okay to go over a few minutes so that we can give other colleagues the opportunity to ask you questions, because I'm sure they will have some. So Juliette, please go ahead.
So Kamari, I'm wondering out loud now that, of course, ICC has come under a severe criticism, not only on disproportionate focus on African cases, but also on the fact that it has failed to implement one of its major components requirement of the complementarity. And it has been criticized as the institution providing distant justice and not having the local presence and expertise. So I have to wonder, based on affective justice, how would that allow ICC as an institution to rectify this primary, to rectify the lack of its accomplishment of its primary directive? One of the primary directives is to be an institution that provides complementary justice to local and national judicial processes rather than taking over and, whizzing everybody away to The Hague. Because I think your concept is so important. So please share your thoughts on what affective justice can do to right things up.
Okay, thanks for that question. It's something that I write about in the second half of the book by the introduction of the concept of geographies of justice. And so thank you for raising this point about distant justice as the basis for critique. What we see is that that certainly the ICC is supposed to be a court of last resort, as per the legal provision that we see in Article 17, and only if a state is unable and unwilling to act would one of the ICC triggers be activated in order to then refer a case. Now, what ICC, pro-ICC advocates would say is that actually what has happened, the effect of ICC justice is that it has triggered positive complementarity. So what's known as positive complementarity, which means that in many cases, states are retooling, they're domesticating the terms of the treaty, and rather than their cases going to the court, the ICC, they're instead scrambling to ensure that they have the mechanisms in place in order to take on a case on its own. And in fact, many at the ICC would say that the successful adjudication of Hassan Habre, for example, which of course is outside of the temporal jurisdiction of the ICC, but part of the international justice domain in general, Some would say that it's actually the positive complementarity of the ICC that produced the cultural and social domain in which Senegal pushed through at Dakar, at the court in Dakar, to adjudicate Hassan Habre's case a couple of years ago. And so they would insist that positive complementarity is the effect of the kind of complementarity that is core to this particular provision in the statute. But to wrap up that, what I would say is that what's interesting in thinking about what justice is to reckon with the geographies and the way that geography matters, that it's a European court, that whether it's international isn't the issue, but it's very far and distant from sites of violence often. And its temporality doesn't necessarily, is often seen as not necessarily dealing with the enabling factors that actually trigger violence. That instead, when you start from a post-2002 period and you don't start from, 1896 or 1924, moments of colonial plunder and displacement of people, if you don't start there as the basis for understanding why it is that people are emotively frustrated or impoverished or in positions of difficulty, but instead you start at the moment in which someone pulls the trigger and kills, it means that you shortchange the basis on which we understand the factors that contribute to justice in the first place. So there are competing questions about what justice is and the geographies of justice and the effectiveness of what you call distant justice. It's just very interesting to make sense of how people differently justify its legitimacy.
Thanks, Kamari. So I think we have time for one more question from me.
Yes, Sophia, go ahead.
And we'll open it to the audience. So I have a couple of questions, but I'm just going to give you a choice if you'd like to talk about one of the three of them. One is to ask you about methods, another one about race, and another one about the notion of truth value in terms of affect, or any particular burning desires, or shall I just pick one randomly? Oh, I think you're muted.
Yeah, they're all terrific. So why don't you pick the one that...
Okay, I'm sure they're all related. I'll try and pick one that's more coherent, because the one about truth is a little me wondering out loud. I know that you've said that, thinking about the ICC as a racist institution is not adequate. And I understand from your talk the way that affects mediate the racialization of justice or injustice. But I'm wondering how you think about the distinction between sort of racialized outcomes of an institution based on this effective mediation and a racist institution itself. And whether it's relevant, I'm thinking about Sarah Ahmed's work on affect, around affects are the way that structures get under the skin. And if these sorts of effective mediations, are they just racism reproduced through feeling, or is there something else that's taking place in that process?
Yeah, great. So I didn't really give a mapped out talk about race per se, so this gives me the opportunity to say a bit more about this. I think one of the problems around international justice is the inability to articulate race and racism and racialization in this domain. Race looks different in different places. The geopolitics of race map out very differently in the US versus in other places. But there are some constants around the ordering of things, the ordering of humankind, and the ways that certain kinds of bodies become expendable. What's important, I find white supremacy, a la conceptualizations of empire important for thinking about the conditions of the possible. So it isn't simply that the institution itself is racist. Yes, there is some of that, but to understand in a more complex and coordinated way, part of what we have to understand is what are the conditions in which it is Kenya or Nigeria or Uganda or Central African Republic and not the US and not Canada and not Japan that become the subjects of this extreme violence. And that requires that we think about, you know, longer standing colonial projects, extractionism, that we think about imperial projects that have produced particular kinds of subjects in particular ways. And in doing that, those conditions of the possible are the conditions that structure the volatility of the state, right? Where extraction becomes the basis for the economy, then it means that when things implode as a result of an election that goes bad, that implosion means that the only job in town was ensuring that your ethnic group won. And when your ethnic group, when you feel that the election has been stolen from you, it also means that it makes it difficult to put food on the table. And so the forms of structuration around race and racism and poverty are fundamental to thinking about the contemporary manifestation of cases in particular regions. And so I think part of what we need to do is to continually think about history and the conditions of the possible and map out the ways that these forms of supremacy continue to play out, whether it's creating exceptionalisms in the technocratic production of the law. So where, you know, certain things are criminalized after 2002, but prior to 2002, when the British colonials were doing it, it wasn't criminal at all. It was actually legal. And that's a technocratic process that is about the protection of particular people and not others. And so there's an important mapping that I've written about and that many scholars have who, like Sarah Ahmed and others, who insist that we continue to think about the forms of structuration that constitute subjects differently. And this is why I think universalism isn't really useful to us. The presumptions of sameness, etc. The reality is that the International Criminal Court operates in an uneven world, a structurally, politically, economically uneven world, which means its manifestations, its rulings, etc., will have uneven consequences. So hopefully that gives you a glimpse of where I go with thinking about race and racialization and white supremacy.
Thank you.
Thank you, Kamari, and thank you, Sophia and Juliette for your educated questions to Kamari. Before I open it to the floor, and then we all agreed that we are going to go over a few minutes, I want to take this opportunity to announce that both Sophia and Juliette will be offering summer courses for GLI over the summer, and in their respective field, they are related to these talks. So I'm going to share the posters with you, particularly for the GLI students who may be on this call, but also for colleagues to get to know what they're about. Oh, I'm not sure we have the privilege to share those. So Sophia, very quickly, and Juliette, could you please tell us what the two courses are about? And then at the same time, I'm going to invite our audience to type a few questions or to say that they want to ask a question while we're doing that. Sophia, go ahead.
Hi, sure, thank you. So I'll be teaching GLI 212. It's a gender, race, and class in a global context. We'll be looking at the history of stereotypes and the way that these are mobilized to support certain oppressive regimes, and get a sense of how to use intersectionality as a tool to consider those regimes. There's no prerequisite for the class. It's going to be asynchronous and online in summer 2, so middle of July to end of August, or beginning of July to middle of August. Yeah, that's the class. Go ahead, Juliette.
Thank you. So I will be teaching a class on a class on human rights, and we're going to have not only the international aspects of human rights, but also local aspects of human rights. So we will examine the international norms and then really take it home. In fact, I was just discussing in one of my classes, the New York human rights law, which happened to be enacted even before the Universal Declaration. So we're going to really focus on human rights, both from a philosophical point of view, legal point of view, socio-economic point of view, etc. So anyone who is interested in the pursuit of the greater good, I hope you will consider the human rights global and local perspective as a challenge for a very condensed 6-week workout.
Thank you, Juliette. So I would like to open the floor now to any of you who may have questions for Kamari before we conclude this event. You can actually speak out loud, unmute yourself. It's a quaint audience, so you can go ahead.
Yes, thank you. And thank you, Kamari Clarke, for your fascinating lecture. I'm Joachim Savelsberg. I'm a sociologist at the University of Minnesota. And thanks to Daniel, who alerted me to the event, I'm with you today. I have two questions, or they're closely related. I so much appreciate your critique of universalistic formal justice. I see all the limitations that are part of a formal justice system, including the exclusion or the limitation of the time horizon that in this case excludes colonialism, for example, as one root cause of current day injustices. At the same time, I also appreciate holding those responsible who are today at the root of violent action. You suggest a different form of justice system. An alternative to that, an alternative suggestion is to supplement the formal justice system with other tools, for example, truth commissions. And I see that in many places, to combine formal criminal justice responses with truth commissions. The second question is about the focus on Africa by the ICC that you critique, rightfully so. It is a troubling situation. But of course, the ICC came into the picture after several ad hoc criminal courts prosecuted actors in different settings that were not African settings. And it was exactly an attempt, in my reading, to take out of the hand of dominant powers the power to create international criminal tribunals when it suited them well, to create a permanent court that would be available in all cases, not just in cases that were objectionable to the United States or some other powerful countries. So in this context, I would also ask, could we conceive of the question not as targeting Africans, but targeting certain African violators of human rights principles, violations that were directed against African populations? I think of the case of Darfur particularly, that I know best, where the populations who were violated were defined as Black African populations, the Zagawi, the Fur, etc. So these are really my questions. Coming up with a new model of criminal justice or supplementing criminal justice by other models? And secondly, is it really about targeting Africans, or is it not a rather different question?
Okay, thank you for that question. So the first part of what I read into the first question is, in a way, a dialectical relationship between recognizing that universalism has its limits, yet wanting to ensure that we hold those responsible who are at the root of violence. And what I should start by saying is that it's not so much that I'm suggesting that we do away with courts. I hope that's clear. In fact, some of the work that I've been doing with the African Union as a technical advisor has involved the erection of an African court with criminal jurisdiction, but to expand the categories of crime so that we think about mercenaryism, we think about drug trafficking, we think about a lot of the economic crimes that are actually toxic dumping and others that are actually at the heart of significant violence in many of these regions. But instead, what we have is a mechanism meant to pursue political crimes, not necessarily those economic crimes that are at the root of violence in the first place. Truth commissions, you know, I don't have enough time to talk about the problem with truth commissions, but what I do, especially in the South African case and the absolving of complicity, the absolving of culpability of white South Africans for the, you know, years of subordination and violence against Black and brown populations. And at the moment in which these mechanisms became tools for adjudication of justice is the moment in which it's no longer, you know, white South Africans who dominated the region for over a century, but instead it's Black Africans. You know, there are some ironies and paradoxes there that are part of the effective response to the deployment of the law to pursue Africans, but at a time when it's no longer viable to pursue them, but instead to replace them with truth commissions. So I'm not necessarily celebrating truth commissions either, but what I think is useful is this new move that we're seeing by the African Union, which is to put in place commissions of inquiry and to ask different questions, that sometimes the law is not the domain and the tool to be used in every context, that many of these crises in sub-Saharan Africa and elsewhere, you know, whether we're talking about elsewhere among Rohingya people in Syria, in Palestine, many of these challenges are not legal, cannot be solved using legal tools, that many of these, that law can play a role, but they're actually political problems that require political solutions, structural inequality, different leveraging, different forms of accommodation, a range of mechanisms that can't simply be addressed by asking who pulls the trigger. There's a limit to that. And so that's why, yes, I absolutely agree that we need to think creatively about how to deal with those who are most culpable for causing harm and violence. And we have to be creative, and we need to at times think outside of the box. It cannot always be the release of an arrest warrant and identifying one person when in fact there's a collective responsibility for violence in many of these contexts. So that's the first question. The second is a question about the ad hoc tribunals and the spirit around the implementation of a permanent mechanism to ensure that there is in place a mechanism to deal with those most responsible. One of the problems with this design is that it isn't actually, this is a moment in which the universal is not universal. Yet another moment, the court is not universal, does not have universal jurisdiction. And many of the economically and politically powerful countries on the Security Council, for example, are not member states of the ICC, the US, Japan, India, China, Russia, that in fact, a third of the state parties are African states that are part of the constituting membership of this mechanism. And so the larger question is, who is outside of the court's remit and why did African states sign on? And in fact, one of the things that my research certainly has shown is that there's a system of linkage in this contemporary period in which signing on to the court is connected to the renewal of IMF loans, the renewal of World Bank loans, the kind of structural adjustment requirements and the indexes that make their countries attractive for investors, etc. Having a high human rights index or a high rule of law index means that it's a safer, more stable country. So there's a much larger set of metrics that are part of the rise of the rule of law, and that make these countries actually subject to the jurisdiction of this court that put other countries outside of it. So to simply say, you have to submit to this jurisdiction, but I'm not going to. And this is a larger structural problem. It's not to say that we celebrate violence or that we need not to stop those who commit mass atrocity violence, but it means that we have to think long and hard about why we're seeing such a pushback. Yes, there are many Africans who want the court to intervene because there are no other solutions, and there are many who would rather see a different result than have an international institution like the ICC. So it really needs to be rebuilt from the bottom up, and we need to think about when the judicial trigger is a relevant trigger and when it's not. And in doing that, we need to think about what justice actually is. How does it circulate? What does it mean and why? And I guess those are really the larger questions that the talk tried to address. How justice is practiced. It isn't a thing out there. It is something that's constituted and made and unmade constantly, and that we have to start to contend with the nature of its unmaking if we're actually going to buy into a transnational modality that will serve more people on this planet.
Thank you, Kamari. I wish we had more time, but I don't want to take any more of your time. So thank you very much. I appreciate it.
Thank you, Joachim, for your question. I'm afraid we're nearing the end of this forum, unless someone really wants to ask a 2-minute question. I could allow this. So perhaps all we can do now is to thank Kamari for her generous talk, her generous answers to these questions. It was an honor to have you today. Apologies for the technical difficulties at the beginning. Those happens. We never quite know why. But thank you for those of you who are here. The event is recorded all the same. So if you feel like someone may have missed out or could benefit from having the recording, we'll be very happy to share it with you. So on that note, I want to wish you a good evening, and thank you, Kamari, for joining us all the way from Toronto.
Great. Thank you all. Thank you, Sophie, for your graciousness around our text snafu, and to everyone for so quickly being willing to, jump to a new alternative. So I love it. I think we found a wonderful one. So thank you to you all for being gracious in making that pivot.
Thank you. It was really a pleasure and honor to have you, Kamari. Bye-bye.
Bye-bye.
Bye, everybody.
Thank you very much.